Thank you so much for having us. This is John Bowser, and my colleague Angela is with us. We are joining you from the Washington, D.C. office of Haynes and Boone. We are both with the patent trials team. Angela, if we could move to the next slide. So today we're going to be talking about statutory estoppel. We're going to be talking about collateral estoppel. We're going to be talking about principles of real party and interest and privity, and how RPI and privity come into play with these estoppel principles. So this slide covers the topics that we will be discussing. If we could go to the next slide, Angel, please. So this slide is a reproduction of the statutory estoppel provisions for RPIs, okay? So there are two provisions I want to cover. First is 315E1, and this applies in proceedings before the patent office. This applies for proceedings like IPRs and re-exams. So IPRs are commonly filed when a party is sued for infringement. There's usually two defenses, one of which is I didn't infringe, and second, that even if I did infringe, the patent shouldn't have issued in the first place. And you can certainly file an IPR, but there's a risk by doing so. If you lose in your IPR, you are stopped. And the provisions here in 315E are rather broad. And we're going to get to a case from the Federal Circuit, which just recently confirmed the broad nature of estoppel. But again, so E1 covers situations before the patent office. So there's a few conditions. The petition has to result in a final written decision, okay? We cannot have estoppel unless we have a final written decision. And for those familiar with IPRs, you're aware of the fact that there are essentially two decisions that the board issues. One is there's an institution decision, and that is where the board makes a preliminary determination on whether or not the petitioner is reasonably likely to prevail. Estoppel does not apply there. Estoppel only applies when there is a final written decision, okay? And we can see in the emphasized text here which parties estoppel applies to. Okay, so it's the petitioner. It's also the real party in interest or the privy of the petitioner. That's important because the petitioner can file its petition, and if the petitioner loses, that loss might implicate other parties, other related parties, okay? So we've got E1, which covers proceedings before the office. Secondly, we've got E2, and this applies in proceedings outside the board, including district court and the ITC. So we've highlighted some of the key language from these statutes to show that this applies to real parties in interest, otherwise known as RPIs, and privies. Once the petitioner has received a final written decision in a first IPR, so there's two timeframes here. Once the petitioner has received a final written decision in the first IPR, that petitioner and its related entities may not request a new proceeding, for example, an IPR or a request for ex parte re-exam, challenging the validity of the same claims that it challenged in the IPR petition. And secondly, if the petitioner received a final written decision, that petitioner and its related entities may not maintain, i.e. continue, a previously filed proceeding. Sometimes you might have a situation where, let's say in January, a petitioner filed a petition, and then in June, the petitioner filed a second petition. Well, if the petitioner receives a final written decision for that first petition, and the petitioner receives an adverse final written decision, the petitioner will be stopped from filing or from maintaining the second filed petition. So if we go to the next slide, please, Angela. So this next slide covers, there's a different wrinkle here on PGR estoppel. So we just talked about IPR estoppel, inter partes review. PGR stands for post-grant review. And generally the estoppel provisions mirror those for PGRs, they mirror those of IPR estoppel provisions in 315E. But the potential scope of estoppel from a PGR is much greater. The reason for this is that in an IPR, the petitioner may only challenge a claim as being anticipated or obvious over prior art consisting of patents or printed publications. In a PGR, however, a petitioner may challenge the claims under additional grounds, including eligibility under 101, which is everyone's favorite topic, indefiniteness and written description under 112, as well as anticipation and obviousness under 102 and 103. So the risk of estoppel in a PGR is much greater because there are more grounds that a petitioner could raise. So practically speaking, if a petitioner receives a final written decision in a PGR, but the petitioner did not challenge the claims as being ineligible under 101, the petitioner may not then challenge the claims under 101 in a later proceeding, whether that's before the board, before the district court, or before the ITC, because the petitioner could have challenged the claims under 101 in a PGR. So the scope is much broader. If you go to the next slide, Angela, please.
Okay, great. So I'll take the next section. Hi, nice to meet everyone. I wish we could be there in person today. And I know you spent a lot of the day talking about estoppel, so I hope we're able to offer maybe some new perspectives. I'm sure you've heard pieces of this before, but hopefully our presentation will help you kind of think about some of these issues in a different way and maybe from some different perspectives. So the next thing we'll cover is just the current breadth of these estoppel provisions that John was just talking about. So in my experience, these estoppel-based arguments have increased significantly in the last, 3, 4, 5 years. Previously, it was not as common as what we're seeing now. I think this is true in both the district court context and in the PTAB context. And I think we'll see, from tracing this history, that's largely because of how the board's institution practices have changed over the past few years. So we'll talk a little bit about that. And I think it's important to give this kind of overview of the history, even though some of the law we'll talk about has changed. I think this does give a background and kind of help illustrate how the stakes are just getting higher with respect to when these estoppel provisions apply. It's getting broader, it's getting a way that's more difficult for parties to raise challenges in multiple forums. So I just think that's kind of important context. So with that in mind, let's talk about a case that is no longer the law, and that would be Shaw Industries. Now, you may have heard of this case or studied this at some point for the law students here today, but this decision we'll see has now been overruled, but it played a very important role in defining the scope of estoppel in previous years. So this was a 2016 decision from the Federal Circuit. And the impetus behind the Shaw decision was the board's previous practice of partial institution. So for those who remember the early years of AIA trials, the board would often grant institution as to certain grounds in your petition, but would deny institution of other grounds. And so I remember when I was a summer associate, for example, at Haynes, Boone in Texas, I had a large project where I spent, a good while researching why the board would deny certain grounds as being redundant and what on earth that meant and how to avoid it and things like that. So those were kind of the issues we were seeing in the early years of IPRs. And sometimes the board would deny certain grounds, not for being redundant, but just for, not finding the arguments persuasive. So long story short, the practice of partial institution by the board was quite common in the early years. So in Shaw, that's kind of what happened. So you can see from the slide, in that case, the board declined to institute some of the 15 different grounds that were raised in the petition. Another thing that's changed is I don't think we often see 15 sets of grounds in petitions these days. But anyways, with respect to the Federal Circuit's opinion, the Federal Circuit concluded that the petitioner could not have reasonably raised the grounds that had been denied during the IPR. And the Federal Circuit's reasoning there was very tied to the language of the statute. So the Federal Circuit had explained that an IPR does not begin until it's instituted. So because the PTO had denied institution as to certain grounds, those grounds were never part of the IPR. And so they tied it to this language of the statute about during an inter partes review. So the overall takeaway from this was that these estoppel provisions would not stop you from raising non-instituted grounds in either the patent office or in district court. So if you tried and were rejected, you were fair game, could continue raising those. So Shaw seemed very reasonable at the time, given the practice of partial institution that it was decided in. But it did lead to kind of divergent outcomes in district court. So after Shaw, there was a pretty wide district court split on the scope of estoppel still. So there were some district courts that said estoppel would apply to grounds that you didn't even include in your petition. And so that was kind of one view. And then the other view was estoppel would not apply if it wasn't something that you had raised in your petition at all. So there were kind of two views that were circulating in district courts after Shaw. And then a couple years later, all of that changed with the Supreme Court's decision in SAS Institute. This was a 28 decision from the Supreme Court. And there the court took up this question of partial institution. And so the question that the Supreme Court addressed was, when the Patent Office initiates an IPR, does it have to resolve all the claims that are challenged in the petition, or may it choose to limit its review to only some of them? And so the court ultimately held the board does have to issue a final written decision with respect to all of the patent claims challenged in the IPR petition. So the board can't pick and choose with respect to the claims that are challenged. So notably, the court was only focused on claims, right? So if I challenged 10 claims, sometimes the board would only institute as to 8 of them. And that's what the Supreme Court was really addressing. The Supreme Court was not talking about grounds directly in SAS Institute, but there was plenty of language and reasoning in the SAS opinion. You may have studied this in law school as well. But there's plenty of reasoning there that says it would apply to grounds as well. So you may remember the court talking about the petitioner is the master of its complaint, the petitioner can define the scope of the litigation, et cetera. So there's a lot of reasoning from that, which shortly after SAS was extended to cover grounds as well. So the Federal Circuit addressed it very quickly after the SAS Institute decision and said that they would treat grounds and claims the same for purposes of applying SAS. And then the PTO also issued guidance on the impact of SAS and said, if we institute a trial, we're going to institute on all the challenges raised in the petition. So between SAS and the cases and this guidance that came shortly thereafter, we now live in a world where institution decisions are effectively a yes or no, right? So the board can either deny institution altogether or institute on all the claims and grounds. And so then the most recent development with respect to how broad this estoppel has become is really a product of that SAS decision and what's happened since then. And this came out just a few weeks ago. This is Caltech versus Broadcom. And essentially, in this case, in district court, the defendants had challenged validity using grounds that the PTAB did not address in earlier IPR decisions. And the district court held that estoppel applied because the defendants were aware of the prior art references in those grounds when they filed their IPR petitions and reasonably could have raised those grounds in their IPR petition. So of course, the estoppel issue was the question on appeal, and the Federal Circuit clarified the law here. They expressly overruled the Shaw opinion that we talked about a few minutes ago. And you can see the quote here at the bottom of the screen. They've clarified that estoppel applies not just to claims and grounds asserted in the petition and instituted, but also to grounds not stated in the petition, but which reasonably could have been asserted against the claims in the petition. So that takes kind of the broader view of estoppel. And I apologize for whatever sirens are outside my window right now. So the Federal Circuit's decision takes this broader view of estoppel, that whether you tried and had it denied or not, you know, like we saw kind of post-Shaw, if you could have possibly raised it in your petition, you're now stopped from asserting that going forward. So after Caltech, if an IPR is instituted and reaches final written decision, the petitioner and any RPIs or privies are basically giving up their 102, 103 case in district court. Of course, you can't, in an IPR, like John was saying earlier, you're not going to give up 101 or 112 because you can't raise those in an IPR. Now, if you're in a PGR context, right, presumably this Caltech opinion would, you know, the logic would extend to that as well. And so you'd be stopped on those grounds if you were seeking a PGR. One thing you might note about this opinion is if you read the opinion when it first came out, it appeared to be even broader than this, which the original opinion said not only is does estoppel cover grounds not raised in the petition, but it also covers claims not raised in the petition. And that was very significant and maybe unexpected. It appears to have been dicta in the court's decision because that didn't seem to be at issue in the case. But however it got there, it was eventually removed. A couple weeks later, the court issued an errata sheet correcting the opinion and changing that language. So there was originally kind of a different discussion surrounding this case that was related to claims. But the current and final opinion appears to be that estoppel applies to grounds that you did not include. Okay, so I'll turn it back over to John to talk about the RPI issues and how we start tying these things together.
Thank you. So we're going to be talking about real party interest and privity. Both of these are types of relationships. Angela, could you move to the next slide, please? Okay, so we have a couple statutory sections here where real party interest and privity come up, right? Number one is section 312A, and this is a statutory section which identifies what needs to be in the petition. And 312A2 says that the petition has to identify all real parties and interests. And there was an evolution here in PTAB practice. In the early days, a lot of patent owners used 312A2. It's kind of a trapdoor, and they wanted to get cases thrown out if they felt like all the right RPIs were not named. And what I meant by evolution was the fact that up until around 2017, the board would only assign a filing date if all real parties and interests were named. So if you had to change the designation of the RPIs in a proceeding, it would get you a new filing date. And sometimes that made the petitioner run afoul of the time bar, which we can see in section 315B. So there is a time limit on when a petitioner, how long a petitioner has to file an IPR petition. Okay, this is what Congress provided, 1 year. Now, we're not going to talk about FENTIV, which kind of calls into question how long a petitioner actually has, but this is what Congress gave, which was 1 year, and said you have 1 year to file it from the date that the petitioner or the petitioner's real party interest or the privy of the petitioner is served with a complaint. So once you get hit with a complaint, the clock starts ticking and you got to move fast. Then we have section 315E, those are the estoppel provisions we discussed earlier, so I'm not going to go over those again. Angela, if you can move to the next slide, please. Okay, so here, this is some guidance in the PTAB's Consolidated Trial Practice Guide. There have been 4 iterations, and the latest one is the Consolidated Trial Practice Guide. There's a first one that was issued in 2012, and then there were 2 updates, and now what we have is the Consolidated Trial Practice Guide, which incorporates all of those versions. So that's what you see on the slide. And what we see on this slide is whether a party who is not a named participant in a given proceeding nonetheless constitutes an RPI or a privy is a highly fact-dependent question. And there are some examples or broad definitions here. And this has somewhat evolved over time, but at the end of the day, this is the best definition that we have for an RPI. An RPI is the party that desires review of the patent. So it may be the RPI, it may be the petitioner itself, or it may be the party or parties at whose behest the petition has been filed. Well, the ultimate goal of an RPI determination is trying to avoid multiple bites at the apple. So let me give you just an example. So let's say I sue Auto Company. I'm the patent owner. I sue Auto Company because they have deeper pockets. Now, Auto Company is accused of infringing because of a part in a car, and that part comes from supplier, right? So there is some type of relationship here in terms of auto company versus supplier, right? And we look at who might be actually interested. Because I sued auto company, they're ultimately or potentially on the hook if there's a finding of infringement. But the supplier might be an RPI because they're the ones who are selling the product to auto supplier, and auto supplier will turn around and ask for indemnification from supplier. So we get in these very fact intensive situations. And so we can see in the trial practice guide, there is some guidance, but it really is very fact specific. Now, the notion of privity, it's a little bit confusing because the situation which I just talked about, where you have auto company and supplier, that can also be a privity relationship because there is a legal relationship. There is a contractual relationship between those parties. Another example of an RPI might be, let's just say Auto Company USA. Well, Auto Company USA is a subsidiary of Auto Company Germany, right? Auto Company Germany owns Auto Company USA. So who's the real party in interest? What we look to for real party in interest is to avoid a patent owner from having to defend itself against multiple challenges by related parties. Seems reasonable. Angela, can we go to the next slide, please? Okay, so we talked a little bit about multiple, or this being very fact specific. Now, here we have some of the considerations that are at play in the trial practice guide. So there's multiple factors, and a common consideration is whether the non-party exercised or could have exercised control over a party's participation in a proceeding. What that means is who's calling the shots here, right? Is it the petitioner or is somebody else calling the shots? We see here that there are some considerations that are commonly at play. For example, a party that funds and directs and controls an IPR or PGR petition constitutes a real party in interest. So you have multiple issues here: funding, direction, and control. And direction and control might seem somewhat similar, but I think of control as ultimately who's calling the shots. Direction is more about what grounds you might want to pursue, whether you challenge the claims on the basis of the Smith and Jones references, which claims you might want to challenge. But control is ultimately who's the one calling the shots. And funding is pretty self-apparent. It's about who's paying the bills. So we have a few examples, and this is a situation where we have a trade association, right? Where a trade association, just because it has members, that alone does not mean that the trade association and all of the other members of the trade association become RPIs. Some patent owners would like it to be that way, but that's not what the law says. So we see what is the relationship with the petitioner? What is the non-party's relationship to the petition itself, including the nature and the degree of involvement in the filing, and the nature of the entity filing the petition. So this is going to come up, and there is a precedential decision where a membership organization called RPX, they were found in one instance to be to not name a real party of interest because their member was sued for infringing a patent. That particular member had previously challenged the patents, were unsuccessful, and that the member organization had its primary membership goals is to act as an intermediary between the patent owners, many times non-practicing entities, and their members. So they're actually, they were almost forming kind of like an attorney-client relationship, and they were serving as an intermediary. And given all of these things, in that particular case, you'll see in a presidential decision, it's called RPX versus Application Internet Time. There, the board found that that membership organization was an RPI, but that was really the only instance. I point this out because there's a lot of litigation over whether a membership organization should automatically name all of its members, and the law is just not there. So if we could go to the next slide, Angela. So RPI determinations, there's a big issue on when these RPI determinations should be made, right? So if you're a patent owner, and I talked earlier about some ways that you could get a petition dismissed, and the petition can be dismissed for a procedural mechanism, that is because the petition didn't name all real parties in interest. So under 312A2, the patent owner could argue, well, you should not hear this petition because the petition is procedurally deficient because you didn't name all real parties in interest. That used to be a trapdoor, right? Patent owners, in some cases, used that as a trapdoor. They said, you didn't name all RPIs, you have to dismiss the petition. Then the board realized that this was getting out of hand. It was really getting out of hand because there was so much energy and time and money spent on RPI fights before the board ever instituted. So the board designated this Shark Ninja case that you see the first case here. And what that stands for is that the board can exercise its discretion to defer an RPI determination until later in the trial. They don't want to waste all this time and effort and money over RPI disputes before you ever get to a decision on the merits. This is most commonly at play when there are no allegations of any time bar violations and there's no statutory estoppel issues. So if the patent owner is just arguing simply, you should have named other parties as RPIs, the board will say, well, thank you for that. We'll take it under advisement and we'll deal with it in the instituted trial when parties can introduce evidence. The second case here is Lumentum. And this was another development, and this was a big development because you remember how I mentioned before about how the board would not, or if they found an RPI violation, they would not allow the petitioner to amend its RPI designation without getting a new filing date. Well, Lumentum changed that, right? Because there was this constant sort of absurdity of petitioners were willing to name other RPIs just to make this fight go away, but they couldn't do it because they would get a new filing date. And if that new filing date meant that you were after the time bar, then the petitioners were stuck up a creek. But Lumentum changed that. And they said 312A2 is not a jurisdictional issue. The board may permit a petitioner to update its RPI designations to avoid a termination. Makes sense, because in fact, the federal rules of civil procedure do the same thing. You don't lose your filing date, you don't lose rights just because you didn't get a designation correct. And then the last one, this is another expansion, and this is a relatively recent case, the Propin Express case, where petitioners may update their mandatory notices to list RPI in this particular situation occurred after institution without changing the case's filing date. So we go to the next slide, please.
Okay, so what we've seen from this is RPI is a very fact-intensive question. It can have, serious impacts on who is being stopped by various decisions. And we're just going to briefly talk about the interesting point that those decisions are often not appealable to the Federal Circuit. You may be familiar with the no appeal bar in the American Invents Act. So this is section 314D, and it's pretty simple and straightforward. The determination whether to institute an IPR shall be final and non-appealable. And yet you would not believe the amount of litigation we have seen with respect to what that provision means, including multiple cases to the Supreme Court. So those two are here. So Quozo from 2016, which also had other issues that were before the court, and then Thrive versus Click to Call in 2020. So really a shocking number of decisions from the Supreme Court in PTAB cases between these and SAS and oil states. It's a great time to be a PTAB practitioner because we are always following what the Supreme Court is doing all the time. So anyway, back to the point at hand. Quozo Speed kind of set forth kind of the generic test of what 314D means. And essentially, it bars review where the grounds for attacking the institution decision relate to questions that are closely tied to the application and interpretation of statutes related to the Patent Office's decision to initiate an inter partes review. So that's pretty straightforward in that case. And in that case, it really was a very clear, or at least in retrospect, a pretty clear application of that 314D bar. Now, Thrive was a little bit more complicated. So for years after Quozo, there was lots of litigation about the 315B time bar, because obviously if you can win a 315B argument, that's the end of the IPR if the board denies institution based on a time bar. And the Federal Circuit had been reviewing decisions on those issues on appeal. And then Thrive versus Click to Call went to the court and changed that significantly. So in Thrive, the court held that this no appeal bar bars review of the board's determination under 315B. So let me switch to the next slide. And so this has had pretty broad implications for your ability to appeal an RPI finding. So 315B is clear after Thrive, right? So if the RPI determination is a 315B issue, the Federal Circuit's not going to talk to you about it. That's just, it's very clear in that regard after Thrive. Now, of course, as we alluded to earlier, there's other statutes where RPI comes up. So we've got 315B, 312A2, like John's been talking about, and then obviously the Estoppel provisions that we're talking about as a whole today. So not long after the decision in Thrive, the Federal Circuit extended that reasoning to appeals from 312A2 issues. That was a case called ESIP, and essentially the court said there's no principled reason to distinguish between those two. So if you're appealing a 312A2 argument to the Federal Circuit saying someone should have been named in RPI, that's not going to be something the Federal Circuit takes up either, based on the current precedent. I've included some other points here on this just to kind of emphasize how serious this no appeal bar is. There are cases also where after the board institutes a case, for whatever reason, including in prior years, RPI related issues, if the board terminates the IPR post institution and kind of vacates the proceedings, that's also not appealable because they basically vacated their institution decision, which is an institution decision. So again, those are not appealable. And then one point that a lot of parties have tried to argue is that, well, some of these issues don't get decided until the final written decision, right? Like John was just talking about, the board will often defer 312A2 issues until the final written decision for efficiency purposes. And so parties have argued, well, that means that since in the final written decision, not the institution decision, it's appealable. But the Supreme Court actually had a paragraph in Thrive that kind of shut down that argument pretty clearly, and the Federal Circuit has followed that guidance as well. So the point here is it's becoming increasingly difficult to appeal these RPI findings after Thrive. It's been extended to the 312A2 context, and so the only remaining context then is the 315E context. And here, oops, I clicked twice, sorry. Here, it's a little bit more ambiguous. I would say there's still room for some arguments here. There's been a couple cases in the Federal Circuit where 315E1 decisions have been appealable, but the reasoning in those cases was very much one of the situations that John was talking about earlier, where essentially, an IPR is going along, and then a final written decision in a different IPR issues, and that is the purported basis for the Estoppel issue. And so the Federal Circuit has said in this Unilock versus Facebook case, where the Estoppel triggering event occurs post-institution in this 315E context, that is reviewable by the Federal Circuit. So this is kind of an exception that's developing. We saw this again a few weeks ago. There was a case called Intuitive Surgical that the same kind of reasoning applied, but it still remains to be seen, I think, whether this means that all 315E issues are reviewable or if it's really based on the timing of what's happening here. So that's just the point to consider following. But as we'll continue discussing today, really our topic and our kind of hypotheticals that we're posing are related more to the 312A2 type issues and those coming up in the final written decision. So this is interesting just for context on the appealability issues, but the primary concerns that we've seen relate more to 312A2. All right.
So this brings us to our topic of discussion, and that's a situation in which a party who is not a party to an IPR proceeding is found to be an RPI of the IPR petitioner. So we go to the next slide, please, Angela.
Yep.
So we have two scenarios here, one of which is where institution is denied based on a failure to name all RPIs. So as Angela mentioned, that institution decision is non-appealable, but the estoppel does not apply because no final written decision. Again, estoppel under 315E only applies when there is a final written decision. So we have, however, Shark Ninja, which is basically where the board is kicking the can down the road and saying, you know what, we're going to hear this RPI decision or this RPI issue, we're going to hear it in the instituted trial. And most likely, if you're going to have an instituted trial, you're going to get a final written decision, assuming the parties don't settle. And there will be an RPI determination, and that is now deferred until the final written decision. So we have this situation where we're kicking the can down the road, and even though you might not have had an adverse RPI determination in an institution decision, and even though estoppel might not apply, now it gets extended because Shark Ninja says we'll wait until the final written decision to decide this. We go to the next slide, please, Angela. So we have a hypo here. And this is a simple hypo, but here we have party A files an IPR petition against the patent, 123 patent. And the patent owner argues that the petitioner should have listed third party as an RPI. Importantly, third party is not part of this case and is not involved in presenting arguments or evidence as to why it should not be named an RPI. The situation usually comes up either as a 315B argument, where a patent owner is seeking to have the board deny institution, or a 312A2 argument, where the patent owner is seeking to have the board either deny institution or at least force another party to be formally listed as an RPI. It can also come up at the board in a 315E argument, as we saw earlier in the Unilock case we discussed. So the estoppel concern we focused on today really comes up when there is a 312A2 argument. If the RPI issue comes up for the first time in an estoppel argument where there is no prior RPI finding from some other proceeding, the party being threatened with no estoppel is there in the proceeding to litigate their own status as an RPI. But if the disputed RPI issue is a 315B issue where a patent owner is arguing that the petitioner is time barred because an IPR was served with a complaint over 1 year before, then you really won't reach the scenario we're discussing here. In that case, if the third party is found to be an RPI, the result is that the institution of the IPR will be denied. So you will never reach a final written decision in that context, and thus will never reach a question of estoppel in district court. So go to the next slide, please, Angela. So here, we've extended the hypothetical. So now we have case number 2. Third party files its own IPR petition against the same patent. Case number 2 is filed, let's just say a couple months after case number 1. Later, the board issues its final written decision in case number 1. If we go to the next slide, Angela, please. So here is an overall picture of that hypothetical scenario. The board determines that the patent is not invalid and the third party was found to be an RPI. So the questions are, is third party stopped from maintaining its own IPR? And is third party stopped from challenging validity in district court? One question that may arise in this scenario is whether issue preclusion means that the third party is stuck with the finding of an RPI status from case number 1, even though third party was not a party to that proceeding. If so, third party could be stopped from continuing its IPR and to stop from pursuing invalidity challenges under 102 and 103 in district court. Go to the next slide, Angela.
Yeah, so the idea here is really who is bound by what factual findings. So this is a tip for the law students here. Like, really make sure you learn these different types of preclusion principles in law school, because they come up all the time in all different areas of law, but they come up frequently in patent law. And probably one of the key cases you've studied in CivPro is Blondertongue, which was a patent case. One of like the most famous issue preclusion cases was actually a patent case. So anyway, just important concepts to learn. So that's kind of what we're talking about here. So you're probably familiar with the basic, requirements of issue preclusion, also called collateral estoppel. Basically, when an issue of fact is actually decided and determined in a final judgment, and the determination is essential to the judgment and is conclusive in a subsequent action between the parties on a same or different claim. And so this is a common definition used by most courts. It's in the restatement, and essentially this is the question here is whether this kind of analysis could force third party in our hypothetical to be stuck with that RPI finding and then bound by the ultimate estoppel provisions to prevent them from pursuing validity issues in district court and in their own IPR proceedings. So I know we're running a little short on time, so I'll speed through some of this so we can get to our kind of more analytical points. But essentially, we do know that PTAB decisions can serve as the basis for issue preclusion. We've seen a Supreme Court decision from the PTAB context in 2015 confirming that agency decisions can be the basis for this. The Federal Circuit's reiterated this. And in a fairly recent case in the Federal Circuit, that the Federal Circuit suggested that preclusion can apply between IPRs as well. So one of the points that we'll discuss today are the different exceptions to issue preclusion. Now, you may already be brainstorming a lot of different ideas about how to avoid the situation. I think there's probably a lot more ideas out there than what we've included here. But our point really is to kind of collect a few kind of quick ideas, things people should be thinking about. And one of those is the exceptions to issue preclusion. So these are found in the restatement, section 28, restatement second of judgments. And I've highlighted here some of the ones that we'll discuss. But essentially, these are, exceptions of broad applicability in the law and things that you don't often just kind of, walk around knowing as a patent lawyer. But I think it's something that's very important to learn and kind of have in your walking around knowledge to understand when you might be able to quickly rebut arguments based on these kind of issues. So I'll turn it over to John to talk first about non-party preclusion issues, and then we'll turn back to some of these exceptions.
Okay, thank you. If we could go to the next slide, please. So a person who is not a party to a suit generally has not had a full and fair opportunity to litigate the claims. So that's Taylor v. Sturgill. But then we look at Taylor v. Sturgill, which also teaches us about who is an RPI, who's privity, and we have the situation, the hypo that we talked about, where a non-party is found to be an RPI to an IPR, but they didn't really have a full and fair opportunity to litigate. So are they bound? So go to the next slide, please. Okay, there's a long list here, and we will be, I'll be quick about this. But so these are just some exceptions to when non-party preclusion is appropriate. One of which is where the party who is a non-party agrees to be bound, right? So I agree to be bound by this estoppel. Secondly, this is one where you have a common situation where there's a substantive legal relationship. So this comment comes up in privity, indemnification. This is a big issue in patents. When there's an indemnification agreement, is there a substantive legal relationship, and should we tie both of those parties to an RPI or privity determination simply because of that contract? And then we can go to the next slide in the interest of time here, Angela, please.
Sure, absolutely. So the idea is, yes, we have this idea of like non-party preclusion, right? Generally, issue preclusion is between two parties, and it's generally not fair to extend it, beyond those who are participating in the proceedings. But there are some circumstances, like John was just referring to in the Taylor case, where that is considered appropriate. And it's a little awkward of an analysis, because that Taylor case, those reasons are used to help understand what is an RPI in the first place. So in a sense, the analysis almost collapses a little bit on itself. So, I think there's ways to kind of sort through that. So that's certainly something worth thinking through, as this would be kind of the more typical application of Taylor. But what we've also included here is just some other options to consider. So in my practice, like one of my mantras is always give the court options that they can work with, so that if they're not buying one argument, they might buy a second one, or something might be more appealing to them for a reason that you may not even understand. So these are just maybe more options to consider on how to avoid having that third party in our hypothetical be bound by a factual finding that apparently relates to it that it was never had a chance to discuss. So one of the first exceptions that is mentioned in Section 28 of the restatement with respect to exceptions to issue preclusion is this idea of not being able to appeal the issue. And so now you're probably thinking, oh, that is why we talked for like 3 minutes about RPI decisions not being appealable. Is there maybe something to work with here on this front? Right, so obviously we know the 315B, 312A2 issues at institution are not appealable, but that's not our main concern with the estoppel point, right? The main concern we've talked about is if we reach a final written decision and the board decides that third party is an RPI, there's a good chance that decision is not appealable because it's a 312A2 issue. You also might be in a situation where that decision is not appealable to the Federal Circuit because the petitioner lacks standing for whatever reason. Maybe it's a trade association or something like that. So there may be different instances where those findings really cannot be appealed to the Federal Circuit. Certainly they can't be appealed by third party because third party is not participating in that proceeding. But even if you look at the IPR petitioner themselves, those findings may not be appealable. And in which case, that might be a good time to bring up, hey, we can't apply issue preclusion here because that factual finding could not be appealed. And that is a traditional exception to this doctrine. So another idea is with respect to one of the later exceptions in Section 28 of the restatement. So this is the idea that the parties sought to be precluded did not have an adequate opportunity or incentive to obtain a full and fair adjudication in the first action. So obviously, if you look at this from third party's perspective, they were not participating in the first action, right? So there's kind of that level of this seems to clearly apply where they weren't even there. How could they have an adequate opportunity? But even if you look at it from the perspective of, treating the IPR petitioner as the one with the adequate opportunity and incentive, maybe they had an adequate opportunity, but perhaps consider whether they had an adequate incentive. Perhaps it was not particularly important to them how the RPI decision came out because that affected someone else, not them. Or perhaps like they're focused on other issues in the appeal that's really not their main thing. They're focused on validity. And the incentive to litigate exception is something the Federal Circuit has referred to multiple times. I think it's kind of on the court's radar in the past, like 5 or 6 years. Not necessarily in this particular context, but in other contexts related to issue preclusion. So I think that's an important one to consider. Another idea, and kind of just extrapolating on what we've discussed, a finding that the third party is an RPI with respect to one patent and one IPR might not necessarily govern other IPRs or other patents. So this is, let's say that, for some reason you've lost all your first issues, but you're at least trying to preserve, hey, let me challenge some other patents. The Federal Circuit has indicated in World versus Bungie a few years ago that the RPI analysis can differ between each IPR. So even in a set of like 5 or 6 IPRs that were filed together at the same time and may seem to be related, the court still said those issues, right, the same issue aspect of the issue preclusion analysis might not be met because perhaps the direction, funding, and control with respect to the first IPR is different than with respect to the second IPR. So that's another possible avenue to consider avoiding a prior RPI finding based on a case that you weren't involved in. So just to kind of sum things up, the idea here is, before just assuming that an RPI finding is going to govern in a separate proceeding, consider why, like what theory supports that being the case. If you're looking at issue preclusion, you need to look closely at what the whether the elements are met, whether it's fair to extend it to a non-party in that context, and whether there's any of these exceptions that apply. And this is just another example of, right, patent lawyers, we have a lot of specialties, looking at this particular type of law that's fairly specialized, but it's important to remember we have to step back and be attorneys that know much more than just patent law as well. We've got to know these exceptions, we've got to know these procedural issues and how it affects our clients. Again, so that's kind of the takeaway here. Like, focus on these broadly applicable issues, and just don't treat this just as a patent law issue, but something that you can use everything else you've learned in law school to get the best results for your client. So unless John has anything else to add, we can wrap up our presentation there. Again, we're so sorry we could not be there in person today. We had planned on it, and then when we had to make the decision, it was kind of in the height of Omicron. So we would have loved to be there, but please feel free to reach out if you have questions about our presentation, or if you'd like to talk about Haynes Boone. We're in the DC office. David O'Brien's there, I think, from our Austin office. So we'd love to chat with you. Also happy to chat about any of this, clerkships, what it's like to be a patent lawyer, et cetera. So thanks again for joining us.